webinar. Before we get started, I just want to make a couple of brief announcements. We know many of you are listening in from far away and are unable to attend local events or programs. That's why we provide this free webinar series. We host multiple webinars per month, so please visit our website to view the current schedule for 2018. Simply visit the website at www.johnson-center.org and click on the webinars link on the right-hand side. New webinars and events are often added, so if you're not on our email list, I do encourage you to visit our website and click on the Join Our Email List link that appears on the homepage. To get instant news and events from the Johnson Center, follow us on Facebook, Instagram, and Twitter, as we do often announce grant and scholarship opportunities, new webinars, research opportunities, and special events and presentations there. And be sure to check out our YouTube channel at youtube.com/The Johnson Center. There you'll find a library of several of our past presentations. We do have many exciting programs still to come this year, including some fun fall and holiday events. On September 22nd and again later in November, we hope you can those of you who are nearby can join us for our next Teddy Bear Clinic, a fun family event coordinated by our Child Life team. We also have recently announced a new program providing sliding fee scale counseling services with additional grants for those in need. And our diagnostic clinic now has a number of grants and supports available in order to assure that families have faster access to assessment services by our staff psychologist. Follow our social media pages or check our website blog for more information. Be sure to follow our colleagues at the Autism Research Institute as they host their own webinar initiative and they share some great resources on their website and social media pages. If you would like a certificate of attendance after today's webinar, look for the link on our YouTube channel in the webinar description. It'll contain instructions on how to get your certificate. If you have questions, you can email them to info@johnson-center.org. My name is Anissa Ryland, and I'm the director here at the Johnson Center. My colleagues have assisted me in preparing the information I'm going to share with you today, as many of us are also parents of children with developmental disorders and have been through this process ourselves. So if you'll forgive me for my allergy voice, let's get started. Parenthood is a nonstop merry-go-round of decisions, planning, errands, joy, laundry, grocery shopping, worry. One day you're changing about 17,000 diapers per day, and the next day you're looking up at a teenager with facial hair. One of the universal truths about parenthood is just how fast it goes. And as our babies turn into teenagers, we have a whole new parenthood curriculum to dive into. The list of considerations parents of teenagers have to research is long and well beyond the scope of one webinar, even as just an introduction. Today we're going to focus on long-term planning for those young adults who need it, be that guardianship or alternatives to guardianship. But before we dive in and focus there, I want to share just a few resources that you might look into for a broader perspective and consideration. Previous webinars that we've had have covered topics related to this transition to adulthood for people with autism and related developmental disorders or special needs. Everything from general considerations to employment issues, to higher education, to sex education, and more. And you can find some of these presentations along with several others on our YouTube channel that I mentioned before. It's at youtube.com/The Johnson Center, and I'll post this link again at the end of the webinar. But as I said before, today we're going to zero in and focus on what considerations and research parents and caregivers can look into when it comes to those legal issues and potential support that might be needed when their child turns 18. But first, I want to make a really important disclaimer. I'm not a lawyer, and the information we're talking about today is not to be construed as legal advice. It's also important to note that every state does have some different requirements. The information I'm going to share with you today was gathered by groups of parents and caregivers who've been through this process and followed the different paths. We offer this information as a guide to introduce the topic and provide you with a framework to move forward in seeking additional resources and other supports. So with that said, I'm assuming if you're tuning in today, it's because your child is a teenager and 18 is approaching. But why does that matter? So what's going to change? For families who have children with needs that may mean they're unlikely to become fully independent, say move away to college or out on their own, this milestone birthday might not immediately conjure up the same urgent planning questions that come up for families who might be making plans for their children to soon leave the nest. But it's no less important, and there are still crucial considerations that really need to be considered and addressed. When a child turns 18, he or she is legally considered an adult, period. As one parent said, it's an abrupt transfer of power. And it doesn't matter if they're in special education, have a developmental disorder diagnosis, or any other issue. As an 18-year-old, they are now an adult in the eyes of the law. So what does that really mean? Well, it means that after midnight on that magical birthday, they can legally make their own decisions about medical treatments, living arrangements, financial management, and more. And this means that you, as the parent or caregiver, no longer have automatic access to your child's medical records, bank records, school records, communications, and so on. And so you really no longer have the automatic right to be involved and included and consulted on the decisions related to those things. This can impact things as mundane as being able to schedule a doctor's appointment for your child. It can be as extreme as your child having a medical emergency and being in the hospital and you really being powerless to be involved in helping them, or even being aware of what's really going on. It can be not being able to access or open bank accounts, being able to see or be involved in higher education plans or ongoing special education plans, and even really having a voice in their living arrangements. All 18-year-olds have the legal right to vote, get married, move halfway around the world. Some families might think this isn't going to impact them because their child is not able to be independent, but it really can have far-reaching implications for every single adult, and we've seen that happen. So obviously this can mean different things for different families, and the needs vary widely even within the autism community. We have kids with autism who are going away to college, some who are staying home and taking higher education classes or getting a job, some that are stay home and stay in their high schools until they turn 22. We have young adults who are homeschooled, and really everything in between and beyond. So the steps that each family are going to take may vary widely. And it's really important to note here, and I'll likely repeat this later, that planning for this transition should begin well before the child's 18th birthday. The different options we're going to discuss can take anywhere from days to weeks to months, so planning ahead really is crucial. Before a child turns 18, there are several things to consider to determine what the best course of action might be. It's important to take into account the self-sufficiency level and potential to learn skills to become self-sufficient. Things you might consider would include whether the child is capable of communicating his or her needs and wants related to their care, whether they have the ability to pursue employment, whether they will require outside care as they grow up, like a group home or assisted living facility or related service, the degree that the child can understand the effects and consequences of any decisions or choices they might make, and the income and finances of the child and that child's family. It's also important to note that you want to look into issues related to health insurance coverage and when that might change if a child is covered under a parent's plan. We'll just talk about some of this a little bit more. One point that really is going to bear repeating is that it really is critical that the child or adolescent's needs and wants are considered when determining how best to support them. Include them in these discussions and decisions to the best of their ability. So as I said in the beginning, today we're really going to talk about some of the most common options that are considered by people with needs for ongoing support, their parents and caregivers, like teenagers with autism. The information we're going to talk about today is going to somewhat focus on the process in Texas, but the steps are similar across the majority of the states. I strongly encourage you to take what you learn here today and use it to research specific requirements in the state where you and your child live to explore these options. So let's start with probably the most well-known option, and that is guardianship. What is guardianship? Well, it's a legal process that's used to provide protection for adults, and again, that means anyone 18 or older, who are considered incapacitated. Now, incapacitated is a legal term that says your child or the person is not able to manage certain areas of their life. Now, before we go any further, I want to be very clear that this term, incapacitated, is not a term that you should take to heart. It in no way describes everything about your child, who they are, what they can do, and what they're capable of. It's really only a legal term that defines some of their abilities right now, specific to independent care. There are 4 types of legal guardianship, and the kind of assistance that the person needs is really what determines what kind is most appropriate. The first is guardian of the person, and this can be awarded in a full or limited state, and we'll talk about that in a minute. In the case of guardianship of the person, the appointed guardian is responsible for the physical well-being of the person, who's also known as the ward, including making medical decisions and choosing how they live. In guardianship of the estate, the person, and then again, this can also be full or limited, which we'll talk about in a minute. The person is responsible for the ward or that person's assets, so their money and any assets they may have. In guardianship of the person and estate, it's a combination of the previous two. And then there's temporary guardianship, and this exists for a specific purpose and a limited amount of time. So let's talk a little bit more about each one of these. In guardianship of the person, as a full guardian, the guardian has the legal right and responsibility to make all personal decisions for that person or the ward. The guardian decides things like where the ward will live, what medical or psychological treatment they'll receive, where they're going to go, whether or not they have contact or limited contact with family and friends. With limited guardianship, the guardian does not make all of those decisions. For example, the court might make the guardian responsible for deciding what medical care the ward will receive, or maybe where the ward will live, but the court might let that ward make his or her own decisions about things like getting married, voting, or driving. So in a limited guardianship, the judge says what decisions the ward can make and states the ward's rights, and those are done in written guardianship orders. If granted full guardianship of the person, the guardian has authority really over all aspects of that ward's care. In guardianship of the estate, then it's what we were talking about. The appointed guardian has the legal right and responsibility to handle all of the ward's money and other financial affairs. However, it's important to note that as the guardian, you're not responsible for the ward's debts just because you're the guardian. The ward's money or resources are used to pay their bills. But the guardian decides, often with the court's approval, what should be done with the ward's property, what bills to pay and when, how to invest the ward's money, and whether or not to enter into any contracts, say, to buy or sell property. If granted limited guardianship of an estate, the court says you're responsible for handling some, but not all, of the ward's financial affairs. The court may allow the ward to make decisions, for example, deciding whether or not to keep or sell property, but might require the guardian to routinely pay the ward's bills. If granted full guardianship of the estate, the guardian then has the authority over all aspects of that ward's estate. Then there's guardianship of the person and estate, or a combination of the last two. A court might appoint someone to be both the guardian of the person and of the estate, and if that happens, the guardian has the rights and responsibilities established by the court. Those duties would include those we discussed before as both guardian of person and estate. In a full guardianship of the person and estate, the guardian really has authority and responsibility over all aspects of the ward's care and their estate. And then there's temporary guardianship. Circumstances sometimes require immediate action to protect a person or an estate, or both. A temporary guardianship might be used to address imminent danger and will sometimes resolve the problem. At other times, a permanent guardianship is the appropriate answer. Temporary guardians have the authority to handle specific circumstances for a limited amount of time. So, for example, in Texas, a temporary guardianship is in effect for 60 days from the date it's awarded or established, unless it's contested in court. Before deciding if a temporary guardian is needed, the court ensures certain legal requirements are met, including things like substantial evidence that the person in question is currently incapacitated, imminent danger to that person or that person's estate, some probable cause that would indicate that the person in question or the person's estate requires an immediate appointment of a guardian. Now, a temporary guardianship is not a finding of permanent incapacity. If the temporary guardianship does not resolve the problem, they may then move on to apply for permanent guardianship. So those are the 4 types of guardianship that exist, but I think it's also really critical to consider the implications of guardianship and the implications for the child or young adult in that ward when it comes to guardianship, because it's really important to take a minute and note that this is not a trivial matter. Under guardianship of the person, an individual loses many of their rights, including things like the right to drive, choose where to live, where to work, to vote, to get married, consent to medical treatments, and more. Many people with intellectual and/or developmental disabilities can manage their own lives with some informal assistance and support, and they don't need a guardian and to have their rights removed. It's important to remember that everyone needs support to make important life decisions, especially as a young adult. Even if a person who has a disability needs some extra help to make some significant life decisions, their right to make their own choices should not automatically be taken away. That's why it's the responsibility of the court to determine whether guardianship of the person is warranted and necessary. So with that said, it is important to consider alternatives, and it's important to remember that guardianship is not for everyone. Later on in the webinar, we are going to talk more about some of the alternatives to guardianship that might be more appropriate to consider. There are some viable and meaningful solutions that can help young adults transition into more independence with support and guidance that's really tailored to their specific needs. So we will talk about those a little bit later, but for now, we're going to get a little bit more into the specifics of guardianship. In this part of the presentation, we're going to provide information on the roles of the guardian, including what they can and can't do. We're going to highlight some of the steps that would be required to establish guardianship and some more information on those alternatives we discussed. So what exactly is guardianship? We've talked a little bit about types, but really what is it? A guardianship is a relationship that's established by the court, by a court of law, between the person who needs help, or the ward as we mentioned earlier, and a person or entity that's called a guardian that's named by the court to help that ward. In Texas, a person does not have a guardian until the application to appoint one's filed, a hearing is held, and a judge appoints a guardian. So we talked about the court and the judge. What is the role of the court in guardianship? Appointed guardians have legal responsibilities, and they're required to perform certain tasks when they're providing support and assistance to their wards. The court decides whether to place limitations on a guardian's authority, that full or limited, and the court establishes how much freedom the ward has to make their own decisions. The court looks at the individuals or programs that are willing to be guardians, and they base the appointment of a guardian on several factors. First, preference is almost always given to appointing a family member as a guardian rather than guardianship programs. The court can disqualify any person or any program from being named a guardian. There are things like, for example, certain criminal convictions are grounds for disqualifying a potential guardian. If a potential guardian owes money or is otherwise indebted to the proposed ward, that can be grounds for disqualification unless that debt is repaid before they're appointed guardian. Once they're appointed, guardians do have a lot of responsibilities, legal responsibilities. A guardian must meet the legal responsibilities that are established by the court, which might, depending on the type and the limitation of the guardian, include things like paying the ward's bills, using the ward's resources, making decisions about and maintaining the ward's assets to the greatest extent possible, ensuring that the ward's medical and living needs are met to the extent that's allowed by the resources that are available. And there are there are annual filing requirements and reports that have to be filed and submitted to the court by the guardian. And guardians are sometimes required to ask for the court's permission and approval for many of the actions that they'll take, and that is all outlined in the guardianship agreement. There are limitations to guardianship, or what a guardian can and can't do. So some of those examples might include a guardian can't prevent a ward from making a bad choice. A guardian is not responsible for bad decisions or choices that their ward makes or for any illegal acts they might commit. A guardian is not responsible for personally funding the ward's living expenses or any past debt. So those bills and things that are paid out of resources that are available to that ward, whether that's Social Security or savings or other forms of income. A guardian can't use force to make a ward take medication or undergo a medical intervention. And legally, a guardian doesn't personally supervise the ward around the clock. Now, while many times if a parent is the guardian, that child lives with the parent and they're providing ongoing care, that's not required by the court. There are guardians who don't live with their wards and just supervise their care. And a guardian can't make the call to place a ward in a mental health care facility. So there are some limitations, and more than what we even went through. So if after hearing this and making those considerations we talked about, you think you want to look into pursuing guardianship and you think that might be the right fit for your child, the first step would be to understand the process. So in Texas, obtaining a guardianship requires either hiring an attorney or completing and submitting the required paperwork yourself, and then going to court to determine the capacity of the person in question. Additionally, you're going to need a physician to complete a form that's called a Certificate of Medical Examination, or CME for short. For the CME, the physician answers specific questions about the person's mental and physical capabilities, and they give their professional opinion about whether the person has capacity to make their own decisions. Now, you do want to keep timing in mind. You can petition for guardianship of your child anytime after they turn 18 years old, but it could take many months to gather all the paperwork and get the appointments and have the physician fill out the form and all of that. So if you think there are good reasons that your child's going to need guardianship starting on their 18th birthday, it's a good idea to start working on this much earlier. Once you gather and file all the completed paperwork, it can take about 30 days for the court to decide if they're going to grant guardianship. So one question we get a lot is, do you need an attorney to file for guardianship? And the short answer is no, you don't have to have an attorney to complete the steps for guardianship. It is possible to file and work with the court directly, particularly if it's uncontested. But guardianship law is complicated, so a lawyer who has experience can help you understand the rules and navigate the process. If you want to find a guardianship lawyer, you can ask other parents who've been through the process or search online on the website of the State Bar Association in the state where you live. Before you hire an attorney, ask about their experience with this process, how many times they've done this, and get a written quote on what it will cost. If you do choose to proceed without an attorney, contact the court in your county and explain to the court clerk that you want to petition for guardianship of an adult child. They should give you the appropriate forms to complete and help guide you through the steps that are required. Now, some courts will charge a fee for the forms, as well as a fee for filing them with the court. If you are low income and can't afford the fee, you can ask the court clerk for a fee waiver application. You may also be able to find some of the forms you need online. Just be sure that the forms that you use are the ones that are used by the court in your county or area. In some parts of the country, there are nonprofit organizations that will provide legal assistance during the process. You may find these through community resources, other parents, or by a reference and referral by the court clerk. And we'll share some resources at the end of the webinar that you can start with. So in general, what are the steps that you would take to applying for guardianship? Well, again, it's really important to remember that the procedures for applying for guardianship may vary by state and county, but here's a little bit of a synopsis of some of the steps required. One thing the court is going to consider is whether or not the petitioner or the person who is seeking guardianship has researched and considered all of the alternatives to guardianship. So it is important to listen to and learn about those alternatives that we're going to discuss a little bit later in the presentation. So the first step really is just gathering up the required forms and getting them completed. So for example, in Texas, the following steps and forms would be required. The applicant or petitioner would first register with the Judicial Branch Certification Commission, and this can be done online. Once that's done, you get a link that would get you to the other information that would include completing the required online guardianship training, submitting to a background check, obtaining that physician CME form, submitting the guardianship application form with any required court fees, and then complete a setting request form for uncontested guardianship. And that would be done after all those other steps are followed. You can see those forms and those steps that are used here in Travis County at the link that's up on the screen. So once you've registered, completed those trainings, completed those forms, submitted them with your court filing fees, you're going to file those forms with the court. You can file those forms either by mailing them to the address that'll be indicated on the forms. I would recommend sending them return receipt so that you know they were received and you get confirmation, or you can hand deliver them to the court. One thing that's important is you want to always keep a copy for yourself. Just in case things get lost or there's missing information, you'll know that you have that copy for yourself. You might make additional copies right away if you're going to be doing your own notice, and we'll talk about that in just a second. So notice or notification means that you, as the person who is petitioning for guardianship, are required to notify certain people of that petition by the court, including the child, if he or she is 14 or older and has not yet consented. You have to notify the parents of the minor child if that's not the applicant. You have to notify the person who's been caring for the child for 60 days prior to the filing. So say if the child is in a group home or under the care of another caregiver, you have to notify them. And then really any other person that's directed by the court and by the judge. Getting notice means that the parties must get copies of those court papers and confirmation that they've received them. The notice is typically done by the sheriff's department. You've heard of people who are served by the sheriff. That just means they provide the paperwork and confirm that they've been notified. The sheriff will hand those papers to the person directly, including the child, as long as they're capable of receiving the papers. As long as they see the child and can confirm they handed it to him, it's fine. Don't worry that their child's going to have a long interaction with the sheriff. That's not the case. Now, in some states, the court will also need to interview the parents and the child if possible before requesting a court hearing. So once you've filed everything in with the court and everyone's received their notice or notification, then in Texas at least, the court will then appoint a lawyer as a guardian ad litem for the child. This person will interview all of the parties and the child if that's possible. If that's not possible, they'll go and observe the child in their home or appropriate location. The guardian ad litem can gain access to medical records, school records, and really any other documents that are relevant to the guardianship. The guardian ad litem may also investigate you as the petitioner, including any criminal history, medical history, and any involvement with the state. They're going to ask questions about how you as a guardian would care for the child, how you would make decisions and provide assistance as the child ages. And the guardian ad litem will then make a recommendation to the court as to whether a legal guardianship is appropriate and whether your guardianship petition should be granted. Now, the guardian ad litem's recommendation is just one piece of evidence that the court is going to consider. Once that's completed, then we move on to the hearing, the guardianship hearing. And I wanted to include this picture because many of the parents that we've talked to or have been through this process, this is pretty much what the courtroom looked like. And I think it's good to be prepared because the hearing can really be an emotional time for parents who are seeking guardianship. The child doesn't have to be present at the hearing, especially if it's a hardship to the child, and that's going to be determined in that physician's medical report that's submitted into evidence. So during the hearing, the judge is going to ask the guardian ad litem to present their findings. They're also going to ask the guardian ad litem how many hours they worked on the case, and then they'll award a fee based on that time involved. It's important to remember that it's your responsibility to pay the fee of the guardian ad litem. This is not the same as your attorney fees if you've used an attorney, because the guardian ad litem represents the child, not the parent or petitioner. So once you as the petitioner have been sworn in, the judge will then ask you questions regarding the child's development, their diagnosis, level of functioning. So they're going to really ask questions that are going to establish whether or not that child is legally incapacitated and in need of guardianship. If all of the parties agree, and that is the guardianship is uncontested, the process will usually go pretty quickly and the court hearing will be less formal. So after the hearing and considering all the evidence, the judge will decide whether or not to appoint a guardian. If they do appoint a guardian, then that new guardian must then file an acceptance of guardianship form with the court. If you're becoming a guardian of the person and estate, you'll likely need to apply for a guardianship insurance bond. So this is an insurance policy. It can be paid yearly, or you can pay a one-time bond at a flat rate. And typically paying a one-time bond at a flat rate is a lot cheaper. The bond essentially protects the child's estate from the misuse of any funds. At the end of the hearing, you're going to be given a notarized letter from the court that proves you then have legal guardianship. There's typically a very small fee for the letter, for the notary fee, and any copies that are made. It is a good idea to request several copies at that time so you have them on hand for any agencies or clinicians or professionals that you work with in the future on behalf of your child or your ward. Now, once guardianship is established, it is possible to change, so it's not permanent necessarily. Modification and restoration are the two types of legal actions that can be approved by a court to change an existing guardianship. So, for example, if a person or a ward, if their rights are restored, then the guardianship is ended or terminated. So, for example, if a child, as they're growing up into a young adult, develop skills to become more self-sufficient and take care of themselves, the court can restore their rights and end or alter a guardianship. If the powers of guardianship are increased or decreased, then the guardianship is considered modified. Termination of guardianship would occur typically when any rights are restored or any other event, say, for example, the death of the ward. So now that we have a better understanding of guardianship and the specifics related to it, let's talk a little bit more about those alternatives. Is guardianship the right choice? Because having a guardian takes away a person's right, as we said before, it really should be the last and best available choice. Before deciding to seek a guardianship, the petitioner or you should really examine all other options and alternatives. In some situations, guardianship is the best choice. However, looking at the other options and ruling out less restrictive alternatives that might allow that person being protected to maintain some or all of their independence is the right thing to do. So some of the questions you might want to consider when you're making the choice on what options might be right are things like, is there a less restrictive alternative available that would meet the needs of that person? Have some of these options been tried but were unsuccessful? And if so, is it possible that they could be changed and tried again? What other resources are available to support a less restrictive alternative? Is the person in question really unable to make his or her own decisions or provide for themselves? Let's say, ask if that person might be nonverbal and unable to communicate with caregivers, therefore really unable to communicate any decisions. Is a surrogate decision maker under a power of attorney available who can help make some of those decisions? And we'll talk about some of these options in more detail in a minute. But these are really just some of the questions you want to start with asking yourself. Some of the many alternatives to guardianship that might be more suitable include things like supported decision making, powers of attorney, special needs trusts, joint bank accounts and other banking and savings programs, or the appointment of advocates and authorization. And we'll talk about each of these. So supported decision making is an agreement that can be used as an informal alternative to guardianship. Through this voluntary agreement, people with disabilities can make their own decisions and remain in charge of their lives. This is done with the support of people who agree to provide ongoing assistance and guidance to the person. The supporter does not make decisions for the person, but provides information, guidance, and support by making sure that the wishes of the person with a disability are known and carried out. So anyone who wants to establish a supported decision-making agreement should look at choosing people that they trust to help them make important decisions, ask those people if they're willing to be a supporter, and determine what kind of decisions they want help with or need help with, and be sure that the supporter knows what they're going to be asked to do. The supporter might help in some or all areas, and that's something we can talk about in a minute. And then they'll complete the supported decision-making agreement. If this is done, you want to have several copies of this agreement around to provide to those relevant agencies and providers. This process really essentially formalizes the process that really all adults go through when they're making decisions, seeking advice, input, and information from knowledgeable loved ones about the issues, so making informed decisions in the best interest of that person. That's something we all do. This just really formalizes that process. So here's an example of what a supported decision-making agreement might look like. You can see there in the middle of the page where the person can designate what areas they wish to have assistance or guidance in by the supporter. So they might say they want help with making healthcare decisions, and they can check that and not others, or with managing their money or property and not others, or how to choose a place to live and maintain that. So they can choose what areas they want support in by checking those, and they can also kind of define what information they can access. So can they access health records? Can they access education records? So it gives them the opportunity to define what access and support they want. Filling out this form doesn't require going to court. It does not require hiring an attorney, and it doesn't really require paying any fees. For the agreement to be valid, at least here in Texas, it needs to be witnessed and signed by two people or a notary public. The person with a disability must have the ability to understand what the agreement is and have the ability to choose who they want to be their supporter. It's an option for a person to have multiple supporters to help with decisions. They would just complete separate forms for each supporter. So for example, someone might designate a parent as someone who's going to help them obtain food and clothing and a place to live and manage health decisions. They might appoint another family member or an attorney or someone else to help manage money and so forth. So you can have different supporters, as many as you want, as long as you fill out a separate agreement for each one. Another option to use would be looking at powers of attorney. So a medical power of attorney, and this is just the start of an example one here, is a document that's signed by a competent adult that would designate a person, be it a friend or family member, who they trust to help make healthcare decisions on their behalf that include everything from typical daily healthcare decisions as well as more serious or even end-of-life decisions. Medical power of attorney allows the person, who's called the principal, to give written instructions that would regarding the type of treatments they might want or not want, to receive. And with this agreement, the principal continues to make their own medical decisions as long as they're capable and able, but it also allows the designated agent to be involved and allows them to stay informed regarding the principal's health care. So with this, if, for example, your adult child is in the hospital and you have medical power of attorney, the physicians and hospital staff can not only share information with you on the status of the adult child who's in the hospital, but also loop you into that decision-making process when deciding care. Without it, without guardianship or a medical power of attorney or a supported decision agreement that indicates you can help make healthcare decisions, most times hospitals can't communicate to you because that would be violating that patient's privacy. There's also something called a durable power of attorney, and this is a document that's signed, again, by a competent adult that would designate a person, again, a friend or family member, who they trust to make financial decisions in the event that they're unable to. This can include things like banking access and decisions, taxes, property, and investments. Because there is the potential for exploitation when someone's given access and authority to help make financial decisions for someone else, it is really important to choose someone who can be trusted as the agent. With a durable power of attorney, the principal has the option for it to go into effect immediately and be ongoing, or only in the event that the principal becomes incapacitated. So this is a really important distinction to make when it's being used as a tool to support a young adult who needs additional support, because you would want that to be immediate so that you could be involved and help them make decisions. You can also get a durable power of attorney for education. And so it's important, this can be important because when a child's in special education and they turn 18, they're considered an adult and they have the right to make their own educational decisions. Since many children with autism or special needs remain enrolled in their school district until they're 22, or sometimes often go on to pursue higher education, this is one way that a parent can continue to be a part of and support the student's educational decision. So for those of you who've had children who've gone to college, you know that I know in all the orientations, they really lecture the parents that the parents don't get access to the student's online portal or to any of their grades or any class communications or really anything. And so you're really, again, that abrupt transfer of power happens and you no longer have that access that you had before. So with children, particularly those who are in special education or if they're in higher education and need ongoing support, having a durable power of attorney for education can allow you as a parent to communicate with the school, to have access to that information and help support your child. It is important to note that if a person with a developmental disability or any other diagnosis is considered legally incapacitated, then they're not able to execute powers of attorney or supported decision-making agreements because they're not legally able to express their wishes and intent. So that's when a guardianship would be the more appropriate alternative. Another option for support would be a special needs trust. So a special needs trust is a trust that is designed to supplement but not supplant or replace any government or private assistance the adult child is receiving. Establishing a trust allows you to specially allocate funds and transfer them to the trust to ensure that they're available as and when is needed by your adult child. Choosing a trustee for that trust can be a difficult decision. It's often a parent or family member, but if for any reason they don't feel they're able to do so, you can look at third parties. Whether you or a third party serves as the trustee really should consider hiring legal counsel to help guide them through the distribution process because it can be complicated. So really one important thing to note here to begin with is that if your child has any assets, which I know can sound silly, but let's say there's grandparents who have a savings account for the child and they give it to the child. It's really important to talk to a knowledgeable accountant or attorney regarding these gifts because structured improperly, they can impact your child's ability to access other important sources of support, and professional guidance can help you make the right decision moving forward. So for example, if when your child turns 18 and they may be eligible for things like Social Security, if they have significant assets in their name just in a regular old bank account, that might impact their ability to access that support. But if it's structured properly in a special needs trust, it shouldn't. There are other special savings programs for people with disability, and these vary by state. So lots of states have different programs. For example, in Texas, there's a program called the Texas Taxable or Texas Able program, and it's set up to encourage and assist individuals and families to save money for the purpose of supporting people with disabilities in order to maintain their health, independence, and quality of life. and it allows them to provide secure funding for qualified disability or medical expenses on behalf of that person that will, again, supplement and not replace other benefits and resources. This savings programs and others like it allow people with a disability diagnosis and their family members and supporters to contribute to a tax-advantaged account that won't impact those other sources of support like Social Security or Medicaid waiver programs. So you can see it can be complicated, but there are lots of great accountants and attorneys out there that have lots of knowledge in setting these up. And a lot of times people make the mistake of thinking that these are really for people who have a lot of money, and that's really not the case. If you're saving anything at all for your child's ongoing care, or have a retirement fund you're contributing to that you think might be used for that care, it really can make a difference to talk to a professional and talk about how to start allocating those funds, or in the future plan to allocate funds that can provide ongoing care for your child who might need it. Some other banking and financial support programs that can help support young adults include things like even something as simple as opening a joint bank account in both your child's name and your own name. This will allow them to have access to the account and make some of their own financial decisions, but will allow you the opportunity to oversee their expenses and account. Social Security I mentioned, and that's another important consideration, and it's really one that would take several more presentations to cover. But one important point that I want to make here is that if you think your child will qualify and need Social Security, be sure to apply on or as close to their 18th birthday as possible. While it might take several months for applications to be processed, and typically it does, once they do get approved, that payment is backdated to the application date. So do that as soon as possible. If it takes, say, 9 months for that application to be approved, they would get funding back to the date they applied. And then another option is the appointment of an advocate and authorization. So an adult child, someone over 18, can create an appointment of advocate, which allows him or her to designate a person who can advocate for them with agencies like the Department of Developmental Services, Department of Human Services, Medicaid, Social Security, and other local authorities. Most of these agencies have their own forms online that are available. Like this one on the screen is page 1 of 9 of the Social Security form that you can find online. And it just allows someone who wants additional support to designate someone as an advocate who can be involved on their behalf. And there are other informal ways that you can provide support and assistance for young adults who are transitioning into adulthood. Some of those could include services and support from state or Medicaid waiver programs. And again, those would vary state by state, but if they have them, you could access those. Finding supportive housing and having a network of people who are connected to the young adult, whether that's a formal group home setting or one that you establish maybe with other families and divide and support responsibilities for the young adults who are there. Or things like daily support and check-ins by family members, hired staff, volunteers, habilitation workers that can check in and provide ongoing and individualized assistance. So I think it's really important to note that these things we've talked about, particularly these informal ways of support and these alternatives to guardianship, you don't have to choose just one. It could be a combination of things that creates the individualized program that your specific child needs. So that could be, a power of attorney along with a joint bank account. That could be a supported decision-making agreement with a special needs trust and maybe appointments of advocates. So depending on the needs of your child and the things they're going to need support in, you can pull in those programs and sources of support to create the exact program that young adult needs. There are many resources that are available to help you understand guardianship and the alternatives to guardianship for a young adult. In Texas, you can get information online from the Department of Human Services, from the court in your county or area, and Navigate Life Texas and other nonprofits and agencies, some of which are listed here. If you do choose to work with an attorney, we can provide you with a list of local attorneys that our families have worked with, or as I mentioned, you can go to the State Bar Association and look for a list. Again, if you hire an attorney, be sure to ask how many times they've gone through this, what their experience is, and get a written quote for those services. I would be wary of the one-size-fits-all online law companies that print out cookie-cutter forms and documents, because it may not necessarily provide you with the most relevant or up-to-date or complete information. There are also national resources, national organizations and nonprofits like the ARC, ASA, Autism Speaks, and many others that have relevant information that can help as well. And then each state has their own agencies and programs that can provide support. And like I said, you can often contact the court in your area and ask for recommendations for information on guardianship or alternatives to guardianship. And really, don't forget that one of the greatest resources and sources of support that you can access is to find other families who've gone through or are going through this process. They're going to know the procedures in your area, they're going to know the programs that offer support, and offer guidance on resources and services. If you don't already know people in your community, you can ask your special education provider or school, any private therapy providers, or contact a local nonprofit that works in your community. They'll likely have resources that they can connect you to. And if that's overwhelming, contact us and we'll help connect you with people in your area. We already know people across the country and can do research to find programs, nonprofits, and other resources in your area if you'd like that assistance. So finally, whether you're choosing guardianship or a set of legal agreements or other alternatives that will allow you to help your adult child make decisions when necessary, it's really always a good idea to explore what steps might be needed to support and protect your child before they turn 18. While this is particularly true if your child has ASD or other special needs, it's really also true if your child has no disability. If you have a child who's going away to college, consider getting a power of attorney that would allow you access to medical support when needed. So it really is something to consider for all children, but in particular for those with special needs. After all, you're really never going to know when an unexpected need might come up, and it's better to be prepared than to try and react in the moment. I want to take just a moment to answer some of the questions that you guys have submitted during the webinar. Let's see. First question is, do we still need a power of attorney if we're granted full guardianship by the court? And the answer is no. If you have full guardianship, that is the same as or better than a power of attorney and should get you access to and the right to be a part of everything that you would need, and a power of attorney would be a duplicate. And honestly, if the court has granted you full guardianship of the ward or the young adult, the likelihood then they can't consent to a power of attorney is great, because if they've been legally deemed incapacitated, they can't legally then execute a power of attorney. But you have everything you need then with that full guardianship. Let's see, do you get to choose the guardian ad litem when you're in court? The answer is no. The court is the judge is the person who appoints the guardian ad litem for your child. That's because it's meant to be independent from you as the petitioner. You may have your own attorney or you might not, but you're representing yourself. And so the court represents or provides a guardian ad litem and appoints them to represent the needs of the potential guardian ward. And that way, that gives them the opportunity to research and speak on behalf of the potential ward to make sure that guardianship is necessary and that the right guardian is chosen. Will the public school help with this process? Often when you're doing transition planning in high school, if your child has an IEP, sometimes during that transition process, they might mention this to you. Sometimes they might even give you a resource or a form. I know there are some school districts in our area that kind of have a resource packet that they provide to families, but they don't do it for you and they don't walk you through it. So it might be mentioned, but it really is something that occurs outside of school. It's something that you have to initiate as a parent, as a potential guardian on your own and go through. So it's really separate from the special education process. So I think that's about it. I want to thank you so much for your time and attention today. I would ask that if you know of resources that we could add to those that are shared today, or if you have any additional questions, please feel free to contact us at the email and phone number that's on the bottom of the screen. If you'd like a certificate of attendance, just look in the description in the YouTube page and you should find a link that will take you to a short quiz that, once successfully completed, will allow you to download a certificate. If you want to receive updates on webinar schedules, be sure and follow us on Facebook or Twitter, or sign up for email notifications. And be sure to check out our library of past presentations on our YouTube channel. Thank you so much for your time today. We really appreciate it, and I hope you have a great afternoon.